truth live from where they decree it. Sylvia speaks, no filter, no buffer. Courtroom drama couldn't get any tougher.
When the gavels first bang, to the witness turns tears. Sylvia's lens captures all your hopes and fears. Uploading justice one trial at a time. Tune in every moment, edges sublime.
Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Faces tell stories, the courtroom can't hide. Sylvia's insights cut through the divide. From jury talks to the lawyer's secret. In Sylvia's world, you know you'll need it. Behind the scenes where whispers are loud, her lens reveals the truth in the crowd. Courtroom secrets laid bare to see. Stay curious with Sylvia Spree. Every objection, every sharp retort, Sylvia's there to give you the report. Exclusive footage no one else can snag. From catchy headlines straight to the tag. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show.
Faces tell.
Hey everybody, hello, my good people. It's just been a day of information on top of information on top of information on top of information. Well, guys, I got so much to tell you today, but the most important one was the breaking news of the lawsuit that was filed, class action. And I have the information on that. We also have information on Eppinger. Something happened today in Eppinger that he was in court. Then we had Mr. Fleetwood was in court as well. It's a lot of 411 today, a lot. So I'm going to go ahead on and start off with the lawsuit. Well, it looks like Mr. Stillwell is going to be a very, very rich man. And here's why. He's suing Fulton County Jail. Really, he's suing Labatt. And guys, Labatt is going to have the money because he was just approved for 4 safety and they just got approved for 494.1 million dollars that they just got awarded. Remember, they kept trying to get money. Well, they got awarded for 2025 for that much money. Shout out to CMT. She's the girl that's been getting all this tea for us. Shout out to CMT. But here is the information right here. It's on the news, right? Breaking news. All right, let's go ahead on and play this. I do not own the rights. Let me go ahead and play. Let me play this. Hold on. Let me put my banner up. Copyright disclaimer. Under Section 107 of the Copyright Act of 1976, allowance is made for fair use for the purpose of criticism, comment, news reporting, teaching, scholarship, and research. Well, guys, we're reporting the news. We are reporting the news. Follow the money. Follow the money. Here we go. Let's go ahead on and play this. Yes, I own CMT. There we go.
Convicted. Most of them have not been convicted of a crime. They're waiting for their day in trial. And they come out of that jail with horrific scars on your body, and some of them get killed.
Hold on, let's go.
Convicted. Most of them have not been convicted of a crime. They're waiting for their day in trial. And they come out of that jail with horrific scars on your body, and some of them get killed before they get their day in trial. Back to Mr. Jackson, Stillwell Jackson. Imagine had he got murdered. Imagine if he was murdered in that trial, in that jail, before his trial ended, right? He could have been murdered because of these unconstitutional conditions of non-working locks and these shanks and knives being made by inmates. He could have been murdered. We would have never known he would have got acquitted, from the jury. So it's very important for the citizens of Fulton County to understand that these are innocent until proven guilty pre-trial detainees.
Thank you.
Coming out of that jail with horrible scars, horrible medical conditions, and some don't make it out at all.
Have you talked to Mr. Stillwell, given his YSL verdict? He'll be released at some point here.
I met with him last week.
I don't know if anxious is the right word, but given the conditions you're describing in the jail, what is his thought on eventually getting out of the jail soon?
I mean, clearly, like anyone else, he can't wait to be released from jail. But right now, he is very relieved that the jury acquitted him of all charges after being in this jail for 3 years and almost losing his life twice. We believe he will be out soon. But we're just thankful that he was able to be alive to see his non-guilty verdict.
And with this injunction of relief, do you take a position on, we've seen the back and forth between the county and sheriff, new jail, rehab this jail. What do you see on behalf of your plaintiffs as the ultimate answer?
This case has been filed, as you can see, against the Fulton County Jail, against Sheriff Labatt and the chief jailer. For the reasons that were mentioned, it's difficult to hold the Fulton County commissioners liable for what happens at the jail, even though they fund the jail. Sheriff Labatt ultimately has responsibility over the jail, so we believe that the proper place for blame here is at the sheriff's office, sheriff's department.
You also named a few corrections officers in the lawsuit as well. How grassroots did you see this problem as? Was that kind of part of the reason why you decided to include employees corrections officers?
Well, let me be clear. The employees were in the Davion Blake case, not in the class action. All right, the class action is just against Sheriff Labatt and the chief jailer. For every case where you have detention officers who ignore conditions in the jail and they know that their inmates or detainees are put in a dangerous condition and they don't do anything about it, it's called deliberate indifference. And in Davion Blake's case, those officers were aware that he was in a dangerous place. He had been stabbed several times before he was killed, and they did nothing to protect him. And that's unconstitutional. So that's why we were able to list them separately in the Davion Blake case.
So I just want to, if you don't mind, just to clarify. So there's a class action lawsuit that's for injunctive relief. That's against Fulton County Jail
And the chief jailer.
And
Chief jailer.
The chief jailer and against Sheriff Patrick Labatt.
Okay.
Right.
And then there's the separate lawsuit for Davion Blake.
Right.
Right. And then you said the lead plaintiff is Shannon Jackson. And
Not for that one. The Shannon Jackson and Kenan Hambrick are the lead class action plaintiffs.
Okay.
Davion Blake that's a separate case just for his estate. Yeah.
Just need to get that.
Sure.
Have you been able to talk to Sheriff Labatt before you filed this class action, or are you just gonna?
That's Joseph right there talking, y'all.
Go through the legal process?
We believe that enough talking has happened, frankly. I mean, I have been suing the Fulton County Jail for many, many years, as you guys have followed, my career and all these cases that we've been filing for many years. The time for talking is over. And the time for just settling cases is also over. It's important to note that, these families should be paid for their loved ones being maimed and killed, no doubt about it. But the class action lawsuit, we need change in Fulton County. We need the jail to change. The state of Georgia has investigated the jail. Nothing happened. Fulton County commissioners have investigated the jail. Nothing's happened. U.S. Department of Justice has investigated the jail, issued their report. Now we want a federal judge to declare that the Fulton County Jail fixes problems.
What's the tangible part of that? If a judge forces that? Is it forcing the county to spend money to have more staffing and to fix these issues that, the things that get turned into shanks and the conditions there, or just what's the tangible part that our viewers can understand?
The tangible part is make all the necessary changes, such as staffing, such as the facility, so the inmates are not making shanks and knives from jail materials, sanitation procedures to make sure that these kind of horrible injuries don't occur, and then to make sure that the judge has oversight of the jail to report back to the court. So the court is satisfied that these changes have been made. And then the court can issue a ruling that is satisfied that the changes have been made. They have someone to answer to other than the Fulton County Commission, who does nothing. That's the point.
Devil's advocate on that point, because you and Sheriff Lott agree on quite a bit of this, actually. And so, he's been crying to the clouds for a while about staffing, about not having the funding to do some of the things that needs to fix up the jail. Could it come to a point where, the Fulton County Commission may need to be involved? And I know we run into that question with Soccer Union.
Right. And that's a thorny legal issue for us as lawyers. If we sue the Fulton County commissioners, we get thrown out of court, right? They're not the sheriff. You can't blame them for the death of Davion Blake. What did they do to kill Davion Blake, right? So we have a hard time suing the commission, to your point. So we have to sue the sheriff because he does have responsibility and the officers do. But the court, to your point, can order the commissioners to make sure that the sheriff has what he needs to make the problems go away and to fix the problem. So we have the case against the sheriff, but I agree with you that the sheriff agrees with us about these problems. He needs the funding, but for legal reasons, we hope that the federal judge understands the legal issues that you brought up and that he's able to order the commissioners to do what they have to do to make sure that the sheriff has what he needs to fix the jail.
What have you heard from the families?
I'm sorry?
What have you heard from the families?
What have I heard? But the families continue to be outraged. I mean, we get calls almost every day from someone in the Fulton County Jail who's outraged at what has happened. And they continue to just feel hopeless. I mean, even when you see these settlements that have happened, like the Sean Thompson settlement, you hear about other settlements, but the problems continue, right? It is time for the Fulton County to stop paying people off and to fix the jail. I mean, we have to, at some point in time, someone has to make sure, for all of our sake, this is all of our jail. All of us who live in and travel through Fulton County could end up in that jail for any possible reason. And what a horrible situation it would be if you can't make it out, if you come out, maimed or diseased somehow due to conditions. So everyone is exasperated with the issues in the jail because nothing happens. You come case after case, death after death. We're back here again, and nothing's changed. We're hoping that this class action lawsuit, finally, a judge will have oversight and force these changes at the jail.
So once the judge establishes the class, who can join that class? Does it have to be people that have been to the jail and have come out alive? Can it be people that have unfortunately died?
You want to speak to that?
It's
Yeah.
people who have suffered what we call an acute injury, an injury that happened at the jail, not something that was existing before, a provable injury that happened as they were detained in Fulton County Jail.
So they have to be alive.
I mean, their families, if they died in the jail and their families can prove that, as he's saying, that it was because of the jail conditions, they will be able to join the class action lawsuit.
And of course, you guys just filed it this week.
Tuesday.
What's
Yeah.
next in the timeline?
Yeah.
Next, we're going to file a motion to certify class, where there'll be two judges that get to decide whether the class is adequately defined as to its scope and the people that can join. And then after that happens, we'll be handling damages issues and the real significant liability issues separately.
You
For
don't
each-
know,
for
you
each
you don't know how long that might take.
That might take a long time.
Yeah, it could take some time, but we would imagine only a few months for the judge to make a decision to certify the class or not. And then we'll put a notice out to the public that the class has been certified. And if you have actionable damages, you are able to join this class action
This
lawsuit.
is Northern District of Georgia.
Atlanta, Northern District of Georgia. But spell your name for them in case they want to.
It's Patrick, Patrick, last name Lead, Leed.
Can you spell the name of Hambrick for me, first and last, please?
K-E-N,
NKE.
K-E-N-G-E-N, in Kenja, and Hambrick, like it sounds, Hambrick. It's also on the lawsuit, which we'll email to you, but it's in Kenja Hambrick. Of course, Shannon Jackson, also known as Shannon Stillwell, you know his name.
Is it Jackson or Stillwell?
It's
It
Jackson.
said Jackson.
He's been referred to in the YSL trial as Stillwell, but his legal name is Shannon Jackson,
Okay.
according to him. When I met with him, so I think he would know.
Okay.
I said, "Man, what is your name?"
Right. Let's start with that.
I've heard it so many ways, but he told me,
I have the
Shannon
lawsuit,
Jackson,
y'all.
and he signed my document, Shannon Jackson. So I'm going to take his word for it. That
And
that's
he is the lead plaintiff in the class action lawsuit.
he
Hambrick.
and well, there are
Hambrick.
two. He
Hambrick.
and Kenjan Hambrick.
Are the
Hambrick,
lead
yeah.
plaintiffs in the class action lawsuit.
Correct.
But the separate one is Davion Blake.
The estate of
For
Davion
damages.
Blake for the life of Davion Blake. He was killed. So yeah, his family is bringing that one.
Gotcha.
Yeah.
My last question: what's your hope for clients like Mr. Jackson that's still in custody, or everyday new detainees are coming in? It seems like the county and sheriff are obviously at a stalemate here, but
They
the
are.
process you're describing is months until it's classified as a class action
Right.
lawsuit. Then we go through the whole legal process of just
Right.
that suit. We could be talking about years here.
Absolutely.
What is your hope that the county and sheriff can do during that year-long process before you can get that relief?
Well, I mean, look, we all know the issues. I mean, we've talked about them for years. I mean, we hope that just by filing this lawsuit, that the Fulton County Commissioners will do more to help repair the jail before the judge has to order them to do so. We hope they just take it upon themselves to, in the pending time that you're talking about. It could take years. So I hope that the Fulton County Commissioners will make changes before the judge orders them to do so. Yeah, but also, the families must be compensated, obviously, for those who have been injured. But I just want to stress enough that, it's not just about compensation, because it's not fixing the problem. We'll be here 10 years from now talking about another 100 deaths in the jail. But we really, really want systemic change. We want the judge, again, to order and oversee the changes at the jail to make sure that they happen.
It's adequate for any new detainees coming in.
Absolutely, yeah. Yeah, and then not to mention that, yeah, this is for people who are there now, but I mean, it has to be fixed for the future. I mean, we have to fix this jail at some point in time. It can't just go on as business as usual with everyone, federal, state, local. We all know the problem, but no one doing anything about it. Hopefully the judge will.
This is more just a random question, but if the judge
All right, taking you out to that press conference live as a class action lawsuit being announced against Fulton County Jail leaders. I just want to recap briefly because we did hop in the middle of that conversation, bringing you as much of that live press conference as we could. This class action lawsuit has two lead plaintiffs on it, and one of those names
I got it
has
right
come
here,
up
y'all.
time and time again in the news. Shannon Jackson, or as he is better known as Shannon Stillwell, or SB, a co-defendant and center of the YSL trial in its final moments that we saw play out. Now part of this class action lawsuit, Shannon Jackson, along with Kendrick Hembick, are the two names that were discussed here. They were
She's saying the wrong name.
incarcerated persons, inmates at the Fulton County Jail that personally said they experienced conditions and treatments that they feel violated their rights. Shannon Stillwell, as you heard from lawyers that we took you out to just moments ago, was stabbed 3 times in the jail, according to those attorneys. And the big message that they were driving home over and over again during this press conference that we just took you to was that this class action lawsuit comes as a call for something to be done at a judicial level for the inmates that are held at the jail that are innocent until they have their day in court and are proven guilty. They are pretrial detainees. And so the jail, of course, over the past several months and years, facing intense scrutiny over crumbling conditions, inmate safety, the Department of Justice even going as far as to launch a federal investigation into the jail, and Patrick Labat himself, who is named in this document, has previously stated that there is some much needed attention to this facility. So we are unpacking the details of this class action lawsuit, and we'll have more information for you on AtlantaNewsFirst.com. Our Atlanta News First political reporter Doug Reardon is also digging into this, and he will have more for you on Atlanta News First in our evening hours. Thank you so much for joining us here on Atlanta News First Plus. We are going to continue to bring you the latest coverage on all things happening here in our community and beyond. So stick around as we bring you back to Local News Live.
Okay, that was the breaking news, y'all. Breaking news. Shannon Stillwell and this young man named Hambrick is suing the jail. And I just went into Pacers. And I am pulling up the document. There are, hold on a second, let me show y'all. There are 221 pages that I'm pulling up that I'm going to get downloaded. So we can go and look at everything. And the cost is $15.80. So it's not, that's all the pages on these. So what's the other ones? $15.80 on this one, because I don't have to pay the first 30 pages, I think. I guess, I don't know. But we're downloading it now. So we'll have it. There it is. All right, here we go. We got it. Thank you, Tressie, for sending $10 towards it. Thank you, Tressie. All right, the class action. Are you guys seeing this? Hold on. Let me see if you guys seeing this. You guys seeing this? Oh, we're still on the same page. Hold on, let me get off that page and go on the other one where we actually got the document. Hold on. This is the first page. Hold on. Who's the attorney on it? Let's go back. I'll go back and show you the attorney. Oh yeah, you're right. I better watermark my stuff. You are absolutely right, Kiki. You are right. Thank you, Nosy Rosie, for the Cash App, $20, y'all. Thank you, guys. Thank you. All right, here we go. Yeah, I'm gonna put my watermark on it. Yes, I'm gonna put my watermark. Hold on a second. You said, who is the attorney on this? Let's go check it out. Thank you, Jasmine, for your Cash App of $10. Appreciate it. We're going to be pulling all the documents when they come out for this case. And it's federal. So it's not going to be shown live. It's going to be, thank you, CMT, for the Cash App of $30. Thank you. All right. So you know, if federal cases do not show it live. So we're going to be in the courtroom. Hold on, let me put my watermark. Hold on a second. Let me put my watermark on here. All right, we got a watermark. And now we're going to present it. We got all the pages. Okay. All right. It says here, Exhibit A for class action complaint. And it has the investigation of Fulton County Jail. And I guess it has the report from the Justice Civil Rights Division. And I guess this is the finding that they have. That one has 60 pages. We're going to go over all of this later, but I wanted to see what the actual complaint is. Okay, this is just executive summary of what happened on the report. So let me close this out, and we're going to go and see what the actual complaint, what it shows as a complaint. Just 1 second. Let's go here. Let me just pull this up for you guys. Okay, let's see. It just has it as numbers and doesn't have the complaint. I gotta go through each page. That's the other part of the complaint. That's the exhibit again. Okay, hold on. Let me show you what they're showing on this one here. This is the policies and procedures on this right here. Thank you, Emmanuel, for $20 towards this. Okay, has here Fulton County Sheriff Office, Jail Operation Standard Operation Procedures, and it has, this one's a 7-page document that was done on February 2nd, 2022, and it gives the, like procedures, sanitation procedures, inspection procedures, and housekeeping program of all the jails in Fulton County. It just give you what it is. Now it says vermin and pests are controlled, and a control plan includes at minimum monthly inspection of the contracted pest control company. So supposedly they have pest control company coming in on a monthly basis. So this is their policies and procedures according to them. Now they have these things highlighted in this plan. And this one here has the plan will provide for daily housekeeping and regular maintenance of these areas by assigning specific duties and responsibilities to the staff and inmates. The facility shall be cleaned and in good repair. That's what it's saying here. That's what they're supposed to do. All right, we're going to go to the complaint. These are just exhibits. Let me go ahead on and do the complaint so we can I'm going through every single one because I don't know which one is the complaint. Hold on. That's not the complaint there. This one here is showing standard procedures again. Let's go to the next one. Complaint should be a big, let's see. This is Exhibit D. This is the policies of, okay, let me just show you guys what this is here. Hold on a second. Let me show you what this is. Later, we're going to go in depth into this later on, but I just want to show you the documents that they have filed with the federal court. It's in the Northern District of Georgia. Anybody that wants to know, and the case number is 24 CV 05658 SEG. That's the initials for the judge that's handling this case, and they filed it on the 10th, which is 2 days ago, was Tuesday. They filed this lawsuit. Okay. It says here that it is the policy of Fulton County Jail to provide adequate space for sanitation closets that are equipped with sink and cleaning implements and is accessible to each living and activity area, and to provide for adequate storage space for inmates' clothing and cleaning supply. So they're highlighting certain things that they have seen from the report from DOJ that was not done correctly. So they're just highlighting certain things in this report. All right. So in this next one here is the sanitation facility inspection, the safety part. All right, let's go in here. Let's go pull that one up. All right. Here is, this was the inspection that's supposed to have been effective of June 2023, 13th day of June. And on here, it shows here, I'm just reading the highlighted part. Procedures. The following inspection are implemented. Weekly sanitation inspection of all facility areas by a qualified department staff member. Comprehensive and thorough through monthly inspection by safety sanitation specialists. At least an annual inspection by federal, state, and or local sanitation or health official or other qualified person. Now, question it is, does that mean those local department, the federal, state, did not do health inspection on the facility? Next one says inspection are to be made daily and monthly, including holidays and weekends. Shift and housing supervisor staff will conduct a daily patrol, including holidays and weekend, of all area occupied by inmates. Any unoccupied area are to be inspected at least weekly. And then it says to ensure all tools, mops, brooms, etc., utilized by staff and inmates are controlled and secured when not in use. So I guess somebody must have got hurt by those equipment. Weekly inspection, written policy and procedures and practices require that security supervisor of qualified designee to conduct at least weekly inspection on all security devices, noting the items needed repair and maintenance. The inspection are reported in writing to the chief jailer or designees, whatever. All right. All right, let's go to the next one. Let me go down to, let me see if we still, these are still, okay, these are just, okay, let me go see if I can find the actual complaint. This is not the complaint, these are still exhibits. Let's see. I'm going down the page to see which one is the exhibit. These are still exhibits. This is still an exhibit. This is exhibit I. I wish they would label it better. Exhibit J. Let's go down a little bit further. These are still exhibits. Still exhibit O. Let's go down. All right, here's the complaint, y'all. Y'all ready? Here is the complaint. Let's go ahead and open that one up. Here is the complaint. You guys see this? Let me make it bigger. Can y'all see this? So Hambrick and Shannon Jackson are the ones that started the class action. Okay. And it's against Fulton County Sheriff Patrick Labatt in his official capacity and Fulton County Chief Jailer John Jackson. And this is the complaint action. The attorney is Michael D. Harper and Patrick W. Lead. Those are the attorney in this lawsuit. Okay. All right. And it says here, despite the presence of a written policy and procedures for safety. Thank you, Nona, for the Cash App. Okay, sorry guys. I'm gonna call out the Cash App after I finish reading some of this information here. And it says, despite the presence of a written policy and procedures for safety, housekeeping, and jail management, Fulton County Jail presents obvious hazardous to the health and well-being of detainees. It's on page 15. And it says, let's see. Hold on a second. Can we start with the introduction? Let's start with the introduction. All the other stuff here is just giving you some counts. Basically, is giving the counts that the civil rights and the rights of the detainees, and it's 42 USC 1983 8th Amendment and 14th Amendment, deliberate indifference to substantially risk of harm and serious injury from persuasive presence of handmade shanks. They put it together. Okay, non-working doors. It's dysfunctional locked doors, mechanism. Let's see. Okay. All right, introduction. Let's go. All right. Plaintiff respectively filed this complaint for declaratory relief, injunctive relief, and damage of on behalf of themselves and a class of similarly situated individual who have suffered or will suffer injury because of defendant's deliberate indifference to the known excessive risk to the health and safety of detainees at Fulton County Jail. Address 901 Rice Street, Northwest Atlanta, Georgia 30318, which violates the detainee's right under the 8th and 14th Amendment of the United States Constitution. Number one, this is an action to protect people detained at Fulton County Jail, address 901 Rice Street, Northwest Atlanta, Georgia 30318, hereinafter Fulton County Jail, from serious harm by the cruel and unusual condition of confinement at Fulton County Jail. Number two, this is an action for damages to people who have been in or in the future will be detained in Fulton County Jail and have suffered damages that arise from defendant deliberate indifference to the known excessive risk to the health and safety of detainee at Fulton County Jail. Number three, Fulton County Jail detainee are at constant risk of danger and serious personal injury and death due to Fulton County Jail crumbling and fractured, which inmates use to craft makeshift knives called shanks as for the use of as a weapon. Fulton County Jail detainees are at constant risk of danger, serious personal injury, and death due to Fulton County Jail's failure to restrict access away from parts of the jail containing readily available material for crafting shanks. So that report for the brooms and the mops and where they're supposed to be kept secure, they basically saying that those items were not secured in the jail, that the detainees were able to access those items in the jail, and that would cause other inmates to make shanks and all kind of weapons. So that's why they showed those exhibits of the different procedures for those, procedures and policy and procedures for where they're supposed to keep the items and who has the keys to them, who have access for them to be able to take it out and things like that. So that's part of that. And it was not maintained properly. Okay. It says defendant failure to perform maintenance to remediate and replace non-working or dysfunctional jail cell doors that can be manipulated by inmates to enter and exit jail cells without authorization. So I personally experienced that. When I was at Rice Street, the doors constantly was like non-functioning. They would have, the thing would like buzz for the door to open and it was not opening. There was one time it got stuck and we weren't able to get out of the room. And then there was time when it would hit the buzzer and it would open and it wouldn't close back. So I personally experienced the malfunctioning of those doors, and that would allow other people to get in. And then sometimes they would put like little things in a way, like books and paper in between the locks, and it would cause the doors to malfunction. So I know firsthand about that craziness from Fulton County. Number 6, it talks about the housekeeping. I'm gonna just keep going because it's a lot to read, and I'm just not feeling it to read all of this. Anybody wants a copy of this, let me know. Then you guys can get a copy because this is a lot. Maybe you guys can find one of those awesome readers on their platform to read this for you, because Sylvia don't like to read. All right. Here's the plaintiff. We can go to the plaintiff part, okay? I know I'm cheating y'all out of this, but y'all know me. Y'all know me. I'm a lazy person. You think I should be able to join the lawsuit? Y'all think I should be able to join a lawsuit? Because my problem that I had there? Isn't that Todd? That is a bold move, suing while you're in custody. Ooh, that is a bold move. That is a bold move. That is a very bold move. Suing while you're in custody. All right, let's go ahead on. Let's see who are the plaintiff. Hold on. Hey, Kiki. All right. Okay, we have Nikenjan Hambrick is a 44-year-old male. Shannon Jackson, aka Shannon Stillwell, born in 1992, is a male. 39. The condition under which a convicted inmate are held are scrutinized under the 8th Amendment prohibition of cruel and unusual punishment, and the condition under which a pretrial detainee are held are reviewed under due process clause of the 14th Amendment, Jacoby versus Baldwin County. You have a case on that. Pretrial prison condition may not be imposed to punishment of pretrial detainee, or impermissible punishment may be inferred if the prison condition at issue is not reasonably related to a legitimate goal, if it is an arbitrary or purposeless ID at 1345. Number 40, a valid prison condition claim has two components. One, an objective component which require that conditions be sufficiently serious. And two, a subjective component which require that prison official exhibit deliberate indifference to prisoners' health or safety. Jordan versus Doe. That's a case law on that one. A prison condition. Okay, that's all it says there. Number 41. A punitive class includes individual detained at Fulton County Jail who has suffered acute personal injury, acute psychological suffering, or mental anguish, or death because of defendant deliberate indifference to the known excessive risk to the health and safety of the detainee at Fulton County Jail, which do not serve a legitimate goal, include but not limited to A, the known hazardous arise from handmade shank, or B, the known hazardous arise from non-working or dysfunctional cell door, or C, the known hazardous arise that from defendant's failure to use correctional practice such as classification, housing plan, assessment of likelihood of victimization, and consideration of gang affiliation, or D, the known hazards arise from filthy, vermin, and parasite-infested unsanitary jail condition, or E, the known hazards arise from unauthorized use of force by Fulton County Jail detention officer, or F, the known hazards around from inadequate provision of medical care. That's me. That's me, y'all. That's me. That's me. I can't be a part of it, y'all. That's me. Y'all remember? That's me. I think I need to put in my paperwork. I'm not trying to be funny. I'm serious. That's me. You remember my medical condition that I had in there? And yeah, y'all remember? And they wouldn't give me my medication. Remember? All right. E. Was I at E? Okay, medical care, including mental health care. Number 42, the condition described in the preceding paragraph are sufficiently serious because they deprive detainee of the minimal civilized measure of life's necessities and otherwise poses an unreasonable risk of serious damage to the health and safety. Chandler versus Crosby. All right. Defendant Patrick Labat is sued in his official capacity as the sheriff of Fulton County, Georgia, a position he held since January 1st, 2021. Defendant Labat is a chief executive of the Fulton County Sheriff Office. Defendant Labat is responsible for the day-to-day operation of the Fulton County Sheriff Office, including the Fulton County Jail. As sheriff, he is required by Georgia law to operate the Fulton County Jail system, to maintain the custody of people held in this jail, and to ensure safe and sanitary condition of confinement. See OCGA 42-4-42-45. Defendant Labat is a resident of Fulton County, Georgia. At all times relevant to this complaint, Defendant Labat has acted under color of the state law. The Fulton County Sheriff Office is a program or entity receive federal financial assistance. See 29 USC 794B. 44. John Jackson is sued in his official capacity as chief jailer for the Fulton County Sheriff Office. Under the Fulton County Sheriff Office Jail Operation Standards Operating Guideline, Chapter Safety, Subject, Sanitation Procedures, Inspection, and Housekeeping Program, effective February 2nd, 2022, Section 7, the chief jailer shall appoint a fire safety and sanitation supervisor and fire safety and sanitation officer who are collectively responsible for coordinating and conducting and documenting fire safety and sanitation inspection by independent agency. At all times relevant to this complaint, Defendant Jackson has acted under the color of state law. The Fulton County Sheriff Office Jail Operation Standard Operating Guideline Chapter, Safety, Subject, Sanitation Procedures, Inspection and Housekeeping Program, effective February 2nd, 2022, is attached wherein as Exhibit B. Allegations of facts. I. Despite the presence of written policy and procedures for safety, housekeeping, and jail management, Fulton County Jail presents obvious hazards to the health and well-being of its detainee. The main facility for holding Fulton County detainee in the Fulton County Jail, located at 901 Rice Street, Northwest in Atlanta. 46. Fulton County Jail is built in 1989. Was built in 1989. 47. Fulton County Jail has an operational capacity of around 1,900 people and has had for many years operated at or above that capacity. 48. Fulton County Jail consists of 3-story lower-rise structure joined to an elevator tower, providing access to 2 housing towers. The North Tower has 7 floors for housing, and the South Tower has 6. Each housing unit has 8 zones arranged in a horseshoe around an elevated control tower. The housing zone have between 16 and 18 cell, split over 2 tiers. The cell opens into a day room with table bolted to the floor, phones, and a kiosk for ordering commissary and submitting grievances, among other things, and a shower for each tier. Exhibit A, paragraph 5. Number 49. The primary entity responsible for the jail are the Fulton County Sheriff's Office, which operates the jail, the Fulton County Board of Commissioners, which funds the jail. 50. The 7-member Fulton County Board of Commissioners is the governing body for Fulton County. Through the Board of Commissioners, Fulton County provides funding for the jail and maintains the jail facility. 51. The county sets funding level for the sheriff's office, but the sheriff is an independent elected official. 52. As stated above, the sheriff is required by Georgia law to operate the jail system, to maintain the custody of the people held in his jail, and to ensure safe and sanitary condition of confinement. See OCGA 42-4-4, 42-4-5. 53. Fulton County Sheriff Office has adopted jail operation standard operation procedure, which are divided into chapters such as safety and subjects such as 1. Sanitation procedure, inspection and housekeeping program, 2. Facility inspection, and 3. Housekeeping, janitorial, laundry and supply storage. 54. Subject: sanitation procedure, inspection and housing program under chapter safety, effective February 2nd, 2022, is attached herewith as Exhibit B. 55. Subject: sanitation procedure, inspection and housing program under chapter safety, effective June 14, 2023, is attached herewith as Exhibit C. 56. Subject: housekeeping, janitorial, laundry and supply storage under chapter safety, effective February 11, 2024, is attached herewith as Exhibit D. 57. Subject: facility inspection under chapter safety, effective June 13, 2023, is attached herewith as Exhibit E. 58. Fulton County Sheriff Office has adopted jail bureau policy and procedures, which are divided into subject, including classification, security, and indexes such as classification of inmates, classification plan. 59. The index: classification of inmates, classification plan under subject, classification security, effective date May 18, 2006, is attached herewith as Exhibit F. Number 60. The policy identified in the preceding paragraph and throughout this complaint are not an exhaustive list of policy and procedures adopted by the Fulton County Sheriff for operation of Fulton County Jail. Plaintiff plans to uncover further policies and procedures that are relevant to this litigation and to plaintiff's allegations. 61. Defendant Labat has publicly admitted that he lacks the resources to carry out his legal mandated responsibility to protect the constitutional rights of pre-trial detainees at Fulton County Jail. 62. The risk of harm arises from the presence of handmade shanks, not working or dysfunctional cell door locks, unsanitary bug-ridden condition, and excessive use of force by detention officer is a long-standing and ongoing reality for detainees in Fulton County Jail. 63. Defendant Labat has explained to the Fulton County Board of Commissioners and to the general public on multiple occasions, including 2021, 2022, and 2023, why there is such a proliferation for handmade knives and shanks at the Fulton County Jail. Detainees at the jail fashion metallic weapons from the crumbling physical infraction of the jail. And I'm sorry, you know that word. Number 64. In the fall of 2021, defendant Labat gave the Fulton County Board of Commissioners a tour of the Fulton County Jail. The tour allowed the commissioner to observe the firsthand the deteriorating infrastructure, the Fulton County Jail infrastructure. Infrastructure. I don't know why I can't see it wrong. Which infrastructure was and still is being used by inmates to fashion metallic knife-like weapons called shanks. 65. On or about April 20th, 2022, a sweep of Fulton County Jail resulted in discovering of nearly 100 knives or shanks. 66. In a dramatic, well-publicized appearance before the Atlanta City Council on October 3rd, 2022, defendant Labat had a jail guard roll a wheelbarrow full of shanks and confiscated from the Fulton County Jail into the city council chamber. In a mid-July 2024 news conference, defendant Labat stated that since June 1st, 2024, there has been 10 stabbing at the jail and that 75 knives, shanks had been confiscated. 68. Defendant Labat has, over a period of several years, repeatedly and voraciously decried the fact that Fulton County allocated funds are for urgent jail priorities such as an inmate security, upkeep of deteriorating jail facility, and staffing. On July 21st, 2023, representative of the National Institute of Correction, NIC, and U.S. Department of Justice, DOJ, and the Bureau of Justice Assistance, BJA, conducted a site visit to Fulton County Jail. This site visit resulted from a September 20th, 2022 request that defendant Labat to the National Institute of Correction for technical assistance. Defendant Labat informed the NIC and BJA representative that during his 10-term, thousands of homemade knives made of material from the deteriorating facility has been confiscated at the jail. 71. Defendant Labat also informed the NIC and BJA representative that detainees often fashion weapons when they do not feel safe. 72. Defendant Labat advised members of the site visit team that the number of ununiformed staff vacancy at the jail was at a crucial staffing shortage level. 73. According to defendant Labat, a housing floor at the jail should ideally have 2 officers in the housing control room, as well as 3 officers who constantly move through the 6 housing zone, providing safety and security tours, making inspection and managing the people detained within the zone. 74. According to the defendant Labat, in practice, there is typically only 1 officer in the housing control room and at most 1 officer moving around the housing zone with nearly 200 detainees. 75. As stated above, the Department of Justice, DOJ, launched an investigation in Fulton County Jail on July 13, 2023. The Department of Justice investigation was premised in part on the Civil Rights of Institutionalized Persons Act, CRIPA, 42 U.S.C. 1997. CRIPA authorizes the Department of Justice to investigate state institutions, including county jails, to determine whether incarcerated people are subject to a pattern or practice of constitutional violation, 42 U.S.C. 1997 A. 78. Among the living conditions at the Fulton County Jail that led to the United States Department of Justice launching a formal investigation of the jail are filthy housing teeming with insects and unsanitary living condition, structurally unsafe jail facility, failure to provide adequate medical care, inadequate mental health care, and rampant violence. 79. Summarizing the reason for DOJ's investigation, Attorney General Merrick B. Garland stated, "We launched this investigation in the Fulton County Jail based on serious allegation of unsafe, unsanitary living condition at the jail, excessive force and violence within the jail, discrimination against incarcerated individuals with mental health issues, and failure to provide adequate medical care to incarcerated individuals." Ryan Buchanan, United States Attorney of the Northern District of Georgia, joined the Attorney General Garland, providing his views of the justification for the DOJ investigation, stating that the recent allegation of filthy housing teeming with insects, rampant violence resulting in death and injury, and officers using excessive force are cause for grave concern and warrant a thorough investigation. According to the Assistant Attorney General Kristen Clark of the DOJ, ongoing investigation of the Fulton County Jail reveals that at one point in 2022, more than 200 weapons were discovered during the sweep of the main jail. 82. Condemning the Fulton County Jail, Assistant Attorney General Kristen Clark said, "The unconstitutional condition that we see too often inside jails and prisons have no place in society today." Number 83. Our investigation into these matters is guided by one core principle. People held in jail and prison do not surrender their constitutional and civil rights at the jailhouse door, Clark said. According to Clark, 84. According to Clark, 87% of the jail population in Fulton County is Black, and the vast majority have not been convicted. They are awaiting bail hearings, competency evaluation, and restoration service, and are detained because of their inability to post bail. 85. DOJ investigators reported credible allegations that inmates of the jail are housed in a facility considered factually unsafe, and that the correctional officers are using excessive force, and that the violence is widespread, resulting in serious injury and murders. Number 2, proliferation of shank. I don't know how to say that word, but y'all know. Detainee popping open locked doors, incident of violence, failure to appropriately classify detainees, and unsanitary living condition at the Fulton County Jail continues unabated. Yeah, I'm getting tired of reading. Just hold on a second. Y'all know I do not like reading, and y'all got me reading this so long, and I'm tired. Yes, it's horrible. Who wants to come up here and read? Are you talking about my horrible reading? I'm tired. Seriously, y'all. Hold on. I'm trying to move this thing so I can make it smaller. Hold on. Lauren, it is not wonderful. Don't lie to me. My reading is not wonderful. I'm thirsty, y'all. I need some water. I need some water, y'all. My mouth is dry. Hold on. Let me get some water. Hold on. Y'all got me reading. Y'all know I hate reading. Hold on. Let me get some water. Hold on. Let me just get some water. I just need a water break. My mouth is so dry. Oh, gosh. Okay. All right, here we go. Sorry about that, guys. Thank you. Thank you for your compliment, but I know you guys are lying because you know me. I do not like to read. I don't care what nobody say about me because I don't like to read, okay? Hold on. What is going on, y'all? My thing is acting up. I can't see what I just did. Hold on, y'all. This thing is like, and you know I don't know how to use this Mac too well. It's messing me up. Hold on. All right, y'all ready? Okay, let's go. All right, where was I at? We said detainees unabated. Okay, 86. We was at 86. We appreciate you reading. Gigi, y'all just be 86. The main point, 232. Child, please don't do it. The main point. Okay, because see, I was trying to read what it is. Okay, let's just read these part. Let's see. And you know, I didn't get a chance to read this before I even got on it. I just got on it to tell you guys that they filed this. Basically, the main point is they made shanks. The doors can't lock. They're not giving them. Oh, hold on. Let's go. Let's move on. A jail incident. Listen to this. This is a jail incident that happened on August. Let's hold on. Let's read some of this incident here. Hold on. Let's go back up. Let's do 2024. Open record request. Listen to this, y'all. Listen to this. Open record request. Hold on. Somebody calling me. Hello? Hey. Guess what? I got somebody who's gonna read for me. Hold on, y'all. Hold on. This is so sweet. Hold on. Let me go ahead and get this document to her. You see how sweet I have some sweet people up in this chat. Y'all some lovely people. I just love y'all. Let me send it to her right now. God, what the heck is going on? Yeah, my stupid thing is acting up. Okay. Okay, I just send it. Okay, yeah, I'm back. I'm sorry. All right, let me put the link in so she can come on up. All right, guys, sorry. I just want to put the link in so she can come up. I mean, anybody want to volunteer? Y'all can now. Oh, y'all want to know how much they suing for? Y'all want to know how much they suing for? Y'all want to know how much? Let's go to that nitty gritty part of it, right? Let's see. Let's see how much they suing for. Hold on. We're gonna look how much it is for. They're suing for. Hold on. Usually at the bottom, right? Okay, this is what they're asking for. Ask for court to assume jurisdiction over the action, certify. This case, action 23. Let's see how much money. We're looking for the money amount. Where's the money part? Where's the money? Medical treatment. They want a trial by jury. But they don't say the amount, y'all. Maybe it's just not, we can't get the amount yet. Do y'all see the amount? Oh, okay. Yeah, you're right. The jury does do the amount. Yeah. Monica, I just put the link in. Please hit the link. I sent it to you. And CMT, I sent it to you as well. So if you wanted to come in and read. Okay, they're gonna have to have the amount of people coming in the lawsuit, right? You still working? Okay. Those who just supported, I'm gonna send you guys a copy of this stuff. The one who sent a donation, I'm gonna send y'all a copy because y'all deserve it because y'all paid for it. So every single person that send the a donation, I'm gonna email you with a copy of the this lawsuit, okay? Because y'all paid for it. Why not? Control F, but search the amount. How much the amount? It's probably not gonna give me an amount. You guys, let me know if you want a copy. If you got a content creator who's interested in it, just let me know. Just as long as they let people know, hey, Sylvia provided this, I'll give them a copy, no problem. Just give me my credit. That's all. That's all I ask for. And so, type the word amount. Okay, type the word amount. Let me go check. Control F, amount. It's not in there. No result for amount. There's no result for amount. There's no result for the amount. You know, people that love to read, like Cat, not William, all these other people that love to read. I don't mind me giving them a copy of this because I don't like to read. It doesn't show the amount, y'all. Look for, okay, let me put the dollar sign. Hold on. Let me put the dollar sign. Dollar sign. Nope, no result for the dollar sign. No result. It's not going to be amount. Am I drunk? You asked me, am I drunk? I'm not drunk. Come on, y'all. Let's not be disrespectful to me. I don't drink. Let's not be disrespectful. All right, we were reading this part here. Okay, hold on a second. Everybody that's been locked up at Wright Street probably would be able to participate in the because let me tell you, let me show you. Okay, we were going to check out the part where something happened to somebody. We were reading. Okay, there it is. All right, here come. August 10th, 2024. Jail incident report attached herein under Exhibit H demonstrate the incident where a detention officer displayed deliberate indifference to a detainee's safety and well-being by ignoring the conduct of detainee and rival detainee in the same housing zone. Each defendant is aware that the jail's failure to effectively implement jail practices for classification, housing plan, assessment of the likelihood of victimization, and consideration of gang affiliation contribute to an perplexual and excessive risk to the health and safety of detainee at Fulton County Jail. Each defendant has failed to take steps to reduce the risk of harm, violating the 8th and 14th Amendment, prohibiting against cruel and unusual punishment. As a direct and proximate result of defendant deliberate indifference to excessive risk of harm, plaintiffs have been injured, suffered severe and permanent pain, suffering, disability, impairment, loss of enjoyment of life, loss of care, loss of comfort, and economic damages, including but not limited to past and future medical expense, loss, income, and other damages. Plaintiff may also require additional medical and or hospital care attention and services in the future. Plaintiff seeks compensatory and punitive damages together with interests and to compensate them for the violation of their rights by defendant. Plaintiffs seek declaratory and injunction relief on behalf of themselves and the class of similarly situated person to prevent further violation of their rights by defendant. Count 4. All right, that's that one. Hold on a second. It's a lot to read, y'all. It's going to take a couple of days for us to go through all of this stuff here. But we can do that if y'all want to. I just wanted to get the the nitty-gritty out that they are being sued, a class action against them for the stuff that's happening in the jail. And it looks like more defendants can hop on to this. Defendant is aware that jail failure to provide medical and mental health care exposes detainee to increased risk of injuries, serious illness, pain and suffering, mental health decline, and death. And each defendant has failed to take steps to reduce the risk of harm, violating the 8th and 14th Amendment prohibition against cruel and unusual punishment. As a direct and proximate result, the defendant deliberate indifference to excessive risk of harm. Plaintiff have been injured, suffered severe and permanent pain, suffering, disability, impairment, loss of enjoyment of life, loss of care, loss of comfort, and economic damages, including but not limited to past and future medical expense, lost income, and other damages. Plaintiff may also require additional medical and or hospital care attention and severe and future and services in the future. I was trying to see what hold on a second. I was trying to see what that other guy suffered. That's the relief right there. Let me see. Let me see what Shannon suffered. Shannon. Let me go do find. Control find Shannon. Let's see what he suffered. Hold on. I want the whole document. Why is it not showing Shannon? Am I not doing something? It's only doing from that page. Hold on. We want all the pages, right? I don't know how to do this. Somebody that has to know how to do these things here could help a sister out. All right, somebody's in the private chat. Hold on. Oh, you're welcome. All right, guys. Anybody wants to come in and come on in and give me your comment while we talk about this. Because I don't. Let's go ahead and talk about this. Let's have a conversation about this. And also, y'all, I want to tell you, Eppinger had a hearing today, and I'm going to show you that hearing, a portion of that hearing. His case went back to the appeals court overturned portion of his case, and I'm going to play that for you guys in a few. But this is a federal lawsuit. Yes, Brandon, it's a federal lawsuit against Fulton County Jail. Yeah, I can't even type. People got me out of character. Phone broke. All right, I just put the link in. Come on in, guys, if y'all want to talk about it. You can come on in, come on up and talk about it. And also, Fleetwood, there was a hearing on him today too. There's a lot of stuff going on in with this case with YSL folks. There's a lot of stuff going on. They have to recategorize the sentencing for Eppinger. They're not going to lower it. I think it says here 19 of. Hey, Mo.
Hey,
How are you?
I'm good. How are you?
I'm good. Did you get the paperwork I just
Yes,
sent you?
I've got it. I've got it. pulling it up right now. I don't know if my cameras are working. This is my first time on here, so I
It's
don't.
good. I see you. I see you really
Okay.
well. But
Okay.
your thing is like sideways. I don't know why you're up and down. You're not a full screen.
Um.
Are you using the phone? There we go. There you go. You got it now.
Okay. Yep, I was using the phone. So.
I need you to go move yourself up. There we go.
Because I can't see it, I don't know what it looks like.
I can see you. Oh, now we just see your bottom part. I don't see your face. There you go. Right there. There you go. I see your face now.
Okay. Let's see. How about now?
Now I see you. I see your face.
Okay. All right. What page are you on?
I was all the way on page, I think, hold on, y'all. I think I was on page, we can start at page 40. I think that's where I was at. Page 40.
Okay, let me scroll up to that.
You could do count 1, cause of action. Page 40.
All right, I'm still getting there. Page 40.
Mm-hmm.
Okay. Page 1, count 1. 151?
Yes.
Okay. The lead plaintiffs and class plaintiffs are entitled to the protection of constitutional rights under the 8th Amendment and the 14th Amendment, including protection from deliberate indifference to their safety and well-being. At all relevant times, the collective defendants were responsible for operating Fulton County Jail, funding operations at Fulton County Jail, directing activities of staff, detention officers, and detainees at Fulton County Jail, and conducting, documenting, and performing necessary and essential functions in the operation of Fulton County Jail. The claims against defendants are based on negligence, policies, customs, and deliberate indifference of the defendant, Sheriff Labatt, defendant Jackson, and all medical and administrative staff and detention officers responsible for the conditions at Fulton County Jail. At all relevant times, defendants acted under the color of state law. At all relevant times, defendant NAPFIR and medical professionals employed by NAPFIR acted with deliberate indifference to the serious medical needs of the class action plaintiffs, which constitutes unnecessary and wanton infliction of pain to class action plaintiffs. Farrell versus West. Fulton County Jail detainees are at constant danger of serious personal injury and death due to Fulton County Jail's crumbling infrastructure, which inmates use to craft makeshift knives, make shanks for use of weapons. The jail incident reports attached here within, exhibits G, H, N, and O, memorialize incidents in which numerous shanks were uncovered, in which detainees state they kept shanks for protection, that they can buy shanks from others, and incidents in which shanks are used in assaults on detainees, including Plaintiff Jackson. Each defendant is aware that the persuasive presence of handmade shanks presents an excessive risk to the health and safety of detainees at Fulton County Jail, and each defendant has failed to take steps to reduce the risk of harm, violating the 8th and 14th Amendment, prohibition against cruel and unusual punishment. As a direct and proximate result of defendants' deliberate indifference to excessive risks of harm, plaintiffs have been injured, suffered severe and permanent pain, suffering, disability, impairment, loss of enjoyment of life, loss of care, loss of comfort, and economic damages, including, but not limited to, past and future medical expenses, lost income, and other damages. Plaintiffs may also require additional medical and/or hospital care, attention, and services in the future. Plaintiffs seek compensatory and punitive damages together with interest to compensate them for the violations of their rights by defendants. Plaintiffs seek declaratory and injunctive relief on behalf of themselves and a class similarly situated persons to prevent further violations of their rights by defendants. Count 2. The lead plaintiffs and class plaintiffs are entitled to the protection of constitutional rights under the 8th Amendment and 14th Amendment, including protection from deliberate indifference to their safety and well-being. At relevant times, the collective defendants were responsible for operating Fulton County Jail, funding operations at Fulton County Jail, directing activities of staff, detention officers, and detainees at Fulton County Jail, and conducting, documenting, and performing necessary and essential functions in the operation of Fulton County Jail. The claims against defendants are based on negligence, policies, customs, and deliberate indifference of Defendant Sheriff Labatt, Defendant Jackson, and all medical and administrative staff and detention officers responsible for the conditions at Fulton County Jail. At all relevant times, defendants acted under the color of state law. At all relevant times, defendant NAPCare and medical professionals employed by NAPCare acted with deliberate indifference to the serious medical needs of the class action plaintiffs, which constitutes the unnecessary and wanton infliction of pain to class action plaintiffs. Farr versus West. Fulton County Jail detainees are in constant danger of serious personal injury and death due to the persistent failures of locking mechanisms for cell doors and zone doors throughout Fulton County Jail. The jail incident report attached here within, Exhibit G, documents an incident of a cell door being popped open in the South Tower, and the jail incident report attached here within, Exhibit P, documents cell doors being repeatedly popped open in the North Tower.
Okay, hold on a second. I wanna take a look at that incident report. Hold on.
Okay.
So it was P, right?
Right. The last one was P, the one before that was G.
Okay, hold on a second. We gotta get that one. Hold on, y'all. I just want to put it together with the incident report. Hold on a second. Hold on. P. Okay, there it is. Hold on, y'all. Let's go take a look. Let's go take a look. This is it, y'all, right here. Y'all see it? It says here that Blake Devontae, birthday, okay. Devontae, on September 30th, 2021, at approximately 21:25, IDO Jackson was assigned to 4th North floor while the floor was locked down on the date of birth, whatever, was working in the tower and told me that an inmate, Blake, and his roommate, Stark, was popping out their cell 507. This incident happened during the day lockdown. Happened every day during lockdown, and maintenance have been called more than twice to fix the door so they cannot pop out. The report number was given today is P001. Okay. So that's the incident report for that one, y'all. Hold on, let's close this one out. You said what was the other
one? It was P and G.
G
is in girl.
Okay, hold on. Okay, there's G. Okay, this one's weird, y'all. Hold on. I'm gonna mute you for a minute. This is the other one right here, y'all. This is the G one. It's all weird. It's like sideways. All right, here we go. I got to turn my face sideways to read this one. On Saturday, August 24th, 2024, Detention Officer M. Smother was assigned to 6 South at the floor officer at approximately 2200 hour while conducting lockdown procedure in Zone 100. I noticed cell 105 was cracked open. During head count, resident Kendrick Jeffrey Deman, booking number 2407124, and resident Watson, Terrence BK 2213610, was seen in their belonging was tampering with and open. An inmate in zone notified me that the resident assigned to 104 burned the hole in a cell 105 and popped the cell door open a few minutes before lockdown. I alerted the Deputy T. Sydney, a water and Deputy J. Guilford on conducting a shakedown of 104 where we found various metal sharp-like objects on the top bunk and inside the light fixtures. The piece of concrete stuff inside a socks. Ooh, they had a piece of concrete stuff inside of a sock, y'all. Sergeant Water started the investigation on resident Baker, DeMarcus BK 2411088, and Jackson Trevan BK 241211722 pertaining to incident report JA 24-2478. Resident Jackson claimed that one of the shanks stated that it was for protection, while resident Baker made no comment on any other shanks. Resident Baker confessed to the wire from the fixture, but verbally mixed up his testimony on whether it was his or not. Two of the sharp like metal weapon was distinctive burn mark on them. They had burn mark on them, y'all, which came from the same area located in cell 105 where the hole was burnt. Due to the pungent smell of the debris and the condition of the room, the hole was burned between Thursday and Friday. Resident Jackson and Baker were searched and placed back into the cell. The watch commander was notified. It says final action. I have reviewed the information gathered by Detention Officer Smothered, DID 38556. Resident DeMarcus Baker and Trevon Jackson shall receive the following jail disciplinary sanction: 3 to 10 possession of weapon, 2 to 13 possession of anything not listed as permitted, due to the possibility of these individuals being the culprit that destroyed the window in cell 105. It is my recommendation that both individual lists be relocated and separated to prevent further cooperation at the end of statement. All right, that's it on that one. Okay, that's that one. Sorry. Let me go back to where she was reading. All right, there we go. We're back on the complaint. Okay.
Okay, I think we stopped at this. I can't seem to get this camera right. Uh-oh. Hello?
It's good.
Okay. All right. 171. Plaintiffs seek compensatory and punitive damages together with interest to compensate them for the violations of their rights by defendants. Plaintiffs seek declaratory injunctive relief on behalf of themselves and class of similarly situated persons to prevent further violations of their rights as defendants. Count 3. The lead plaintiffs and class plaintiffs are entitled to the protection of the constitutional rights under the 8th Amendment and 14th Amendment, including protection from deliberate indifference to their safety and well-being. At all relevant times, the collective defendants were responsible for operating Fulton County Jail, funding operations at Fulton County Jail, directing activities of staff, detention officers, and detainees at Fulton County Jail, and conducting, documenting, and performing necessary and essential functions in the operations of Fulton County Jail. The claims against defendants are based on negligence, policies, customs, deliberate indifference of defendant Sheriff Labatt, defendant Jackson, defendant Nafcare, and all medical and administrative staff and detention officers responsible for the conditions at Fulton County Jail. At all relevant times, defendants acted under the color of state law. At all relevant times, defendant Nafcare and medical professionals employed by Nafcare acted with deliberate indifference to the serious medical needs of the class action plaintiffs, which constitutes the unnecessary and wanted infliction of pain to class action plaintiffs. Fulton County Jail's classification system does not conform to generally accepted jail practices because it relies almost exclusively on arrest charges and ignores other risk factors, including custody conduct. Exhibit A, page 17. The August 10th, 2024 jail incident report attached here within under Exhibit H demonstrates an incident wherein a detention officer displayed deliberate indifference to detainees' safety and well-being by ignoring the conduct of the detainee and rival detainees in the same housing zone. Each defendant is aware that the jail's failure to effectively implement jail practices for classification, housing plans, assessment of likelihood of victimization, and consideration of gang affiliations contributes to and perpetuates an excessive risk to the health and safety of detainees at Fulton County Jail. And each defendant has failed to take steps to reduce the risk of harm, violating the 8th and 14th Amendment prohibition against cruel and unusual punishment. As a direct and proximate result of defendants' deliberate indifference to excessive risk of harm, plaintiffs have been injured, suffered severe and permanent pain, suffering, disability, impairment, loss of enjoyment of life, loss of care, loss of comfort, economic damages, including but not limited to past and future medical expenses, lost income, and other damages. Plaintiffs may also require additional medical and/or hospital care, attention, and services in the future. Plaintiffs seek compensatory and punitive damages together with interest to compensate them for the violations of their rights by defendants. Plaintiffs seek declaratory and injunctive relief on behalf of themselves and a class of similarly situated persons to prevent further violations of their rights by defendants. Count 4. The lead plaintiffs and class plaintiffs are entitled to the protection of constitutional rights under the 8th Amendment and 14th Amendment, including protection from deliberate indifference to their safety and well-being. At all relevant times, the collective defendants were responsible for operating Fulton County Jail, funding operations at Fulton County Jail, directing activities of staff, detention officers, detainees at Fulton County Jail, and conducting, documenting, and performing necessary and essential functions in the operation of Fulton County Jail. The claims against defendants are based on negligence, policies, customs, deliberate indifference of defendant Sheriff Labatt, defendant Jackson, and all medical and administrative staff and detention officers responsible for the conditions at Fulton County Jail. At all relevant times, defendants acted under the color of state law. At all relevant times, defendant Nafcare and medical professionals employed by Nafcare acted with deliberate indifference to the serious medical needs of class action plaintiffs, which constitutes unnecessary and wanted infliction of pain to class action plaintiffs. Farr versus West. The experience and injuries of lead plaintiff Hambrick are memorialized in a handwritten medical emergency code report attached here within as Exhibit J. Nafcare medical records attached here within as Exhibit K. Peachtree Medical Center records attached here within as Exhibit L. And photographs of lead plaintiff Hambrick upon release attached here within as Exhibit M. The filthy, parasite, and vermin infested and overall unsanitary conditions are well documented. Each defendant is aware that the jail's failure to remedy filthy, vermin, and parasite infested and overall unsanitary conditions contributes to and perpetuates an excessive risk to the health and safety of detainees at Fulton County Jail. And each defendant has failed to take steps to reduce the risk of harm, violating the violating the 8th and 14th Amendment prohibition against cruel and unusual punishment. As direct and proximate result of defendants' deliberate indifference to excessive risks of harm, plaintiffs have been injured, suffered severe and permanent pain, suffering, disability, impairment, loss of enjoyment of life, loss of care, loss of comfort, economic damages, including but not limited to past and future medical expenses, lost income, and other damages. Plaintiffs may also require additional medical and/or hospital care, attention, and services in the future. Plaintiffs seek compensatory and punitive damages together with interest to compensate them for the violations of their rights by defendants. Plaintiffs seek declaratory and injunctive relief on behalf of themselves and a class of similarly situated persons to prevent further violations of their rights by defendants. Count 4. The lead plaintiffs or class plaintiffs are entitled to the protection of the constitutional rights under the 8th Amendment and 14th Amendments, including protection from deliberate indifference to their safety and well-being. At all relevant times, the collective defendants were responsible for operating Fulton County Jail, funding operations at Fulton County Jail, directing activities of staff, detention officers, and detainees at Fulton County Jail, and conducting, documenting, and performing necessary and essential functions in the operation of Fulton County Jail. The claims against defendants are based on negligence, policies, customs, deliberate indifference to defendant Sheriff Labatt, defendant Jackson, and all medical and administrative staff and detention officers responsible for the conditions at Fulton County Jail. At all relevant times, defendants acted under color of law. At all relevant times, defendants NAFCARE and medical professionals employed by NAFCARE acted with deliberate indifference to serious medical needs of the class action plaintiffs, which constitutes the unnecessary and wanted infliction of pain to class action plaintiffs, Farrar versus West. Fulton County Jail. I'm sorry. Hang on one second because it closed. Real quick, hang on. Sorry about that. Trying to think, what page were we on?
I was asking. Oh, it's oh my God. You have two things open? Because I hear repeat.
No, I had the actual email open and by mistake it closed. The email with the actual document.
Yeah, but I hear myself twice. You have two equipment open?
No.
I might be open because I hear my. Oh, did I hear it, guys? You have two things open. You might have the YouTube open as well as StreamYard because I hear myself.
Okay, I've got the YouTube open on my laptop and StreamYard open on my phone.
So turn the YouTube down, your laptop down, mute it.
Yeah, I've got it on mute. It's mute.
Can you? Hello? No, I still hear myself. No, I don't hear myself anymore. Okay, I'm good.
Okay. What page did we stop at before it got closed?
You was at section 4.
Okay.
Let me go back and tell you what page it is. Hold on a second.
All right, that's section 3.
Page 49.
Okay. Okay. The experience and injuries of lead plaintiff Hambrick are memorialized in handwritten medical emergency code report attached here within Exhibit J. NAFCARE medical records attached here within Exhibit K. Peachtree Medical Center records attached here within Exhibit L, and photographs of lead plaintiff Hambrick upon release attached here within as Exhibit M. The filthy, parasite, and vermin-infested and overall unsanitary conditions are well documented. Each defendant is aware that the jail's
Can
failure
you
to
hold on a second? I want to check M out. I want to
Okay.
bring that one out. Hold on a second. I hear myself again.
I haven't touched anything.
I don't know why it's acting like that. It's weird. Okay, let me go open up M. Hold on, y'all. Just bear a minute with us.
I got vitamin C.
Hold on. All right, here's M. Oh, y'all should see him. Oh, hold on, y'all. Let me show y'all. Oh, hold on. Let me show y'all what he looked like. Oh, y'all, let me show y'all. Look at this. Look at this. Look. Y'all see that? Y'all see that?
I don't see it.
Y'all don't see him? Burnt. He looked like he burnt. Y'all don't see that?
I don't see anything coming up.
Look on the computer. Y'all see him? Do y'all?
I just see you and I.
Huh?
I just see you and I. Oh, oh.
Y'all see that?
Oh, wow.
Look at the back of his head. Look at the, oh, Jesus.
Wow. God bless him. God bless him.
Oh my God.
Wow.
Look at his arm. They look like they burned him all over.
They need to close that jail down.
Oh my
Not
God.
now, but right now.
Look at his arm, Joe. It's on his arm. It's on his back of his head. Okay, I'm sorry. Go ahead. I just wanted to show y'all while we're reading the part. So, okay, let me go back and. This is like terrible. Oh Lord. Okay, we're on page 48, right?
49.
49. Okay.
I think 191.
Okay, I'm there.
Okay. Each defendant is aware that the jail's failure to remedy filthy, vermin, and parasite-infested and overall unsanitary conditions contributes to and perpetuates excessive risk. I'm a little shook up from that picture. Like, okay.
I know, y'all. I don't know if I can do this no more. Sorry.
Perpetuates excessive risk to the health and safety of detainees at Fulton County Jail. Each defendant has failed to take steps to reduce the risk of harm violating the 8th and 14th Amendment prohibition against cruel and unusual punishment. As direct and proximate results of the defendant's deliberate indifference to excessive risk of harm, plaintiff has been injured, suffered severe and permanent pain, suffering, disability, impairment, loss of enjoyment of life, loss of care, loss of comfort, economic damages, including but not limited to past and future medical expenses, lost income, other damages. Plaintiffs may also require additional medical and/or hospital care, attention, and services in the future. Plaintiffs seek compensatory and punitive damages together with interest to compensate them for the violations of their rights by defendants. Plaintiffs seek declaratory and injunctive relief on behalf of themselves and a class of similarly situated persons to prevent further violations of their rights by defendants. Count 5. The lead plaintiffs and class plaintiffs are entitled to the protection of constitutional rights under the 8th Amendment and 4th Amendment, including protection from deliberate indifference to their safety and well-being. At all relevant times, the collective defendants were responsible for operating Fulton County Jail, funding operations at Fulton County Jail, directing activities of staff, detention officers, and detainees at Fulton County Jail, and conducting, documenting, and performing necessary and essential functions in the operation of Fulton County Jail. The claims against defendants are based on negligence, policies, customs, and deliberate indifference to defendant Sheriff Labatt, Defendant Jackson, and all medical and administrative staff and detention officers responsible for the conditions at the Fulton County Jail. At all relevant times, defendants acted under the color of law. At all relevant times, defendants NAPCare and medical professionals employed by NAPCare acted with deliberate indifference to the serious medical needs of the class action plaintiffs, which constitutes unnecessary and wanton infliction of pain to class action plaintiffs, Farr versus West. Fulton County Jail officials routinely use unreasonable force, often without attempting to resolve this situation peacefully. Although jail policy requires all available alternatives to be used before resorting to physical force, officers rarely, if ever, try to de-escalation techniques or even call for assistance before using force. In some cases, officers do not even give commands or verbal warnings before resorting to force. Exhibit A, page 36. The August 10th, 2024 jail incident report attached here within under Exhibit H demonstrates an incident wherein a detention officer did not call for assistance, give a verbal command or warning, or resort to any alternatives before using physical force on detainee who received verbal harassment from rival detainees due to his LGBTQ status. Each defendant is aware that the unauthorized use of force is a direct and excessive risk to the health and safety of detainees at Fulton County Jail, and each defendant has failed to take steps to reduce the risk of harm, violating the 8th and 14th Amendment prohibition against cruel and unusual punishment. As a direct and proximate result of defendants' deliberate indifference to excessive risk of harm, plaintiffs have been injured, suffered severe and permanent pain, suffering, disability, impairment, loss of life, loss of care, loss of comfort, economic damages, including but not limited to past and future medical expenses, lost income, and other damages. Plaintiffs may also require additional medical and or hospital care, attention, and services in the future. Plaintiffs seek compensatory and punitive damages together with interest to compensate them for the violations of their rights by defendants. Plaintiffs seek declaratory and injunctive relief on behalf of themselves and a class of similarly situated persons to prevent further violation of their rights by defendants. Count 6. The lead plaintiffs and class plaintiffs are entitled to the protection of the constitutional rights in the 8th Amendment and 14th Amendment, including protection from deliberate indifference to their safety and well-being. At all relevant times, the collective defendants were responsible for operating Fulton County Jail, funding operations at Fulton County Jail, directing activities of staff, detention officers, detainees at Fulton County Jail, and conducting, documenting, and performing necessary and essential functions in the operation of Fulton County Jail. The claims against defendants are based on negligence, policies, customs, deliberate indifference of defendant Sheriff Labatt, defendant Jackson, and all medical and administrative staff and detention officers responsible for the conditions at the Fulton County Jail. At all relevant times, defendants acted under color of law, of state law. At all relevant times, defendants NAPCare and medical professionals employed by NAPCare acted with deliberate indifference to serious medical needs of class action plaintiffs, which constitutes the unnecessary and wanton infliction of pain to class action plaintiffs, Farr versus West. Each defendant is aware that the jail's failure to provide medical and mental health care exposes detainees to increased risk of injury, serious illness, pain and suffering, mental health decline, and death. And each defendant has failed to take steps to reduce the risk of harm, violating the 8th and 14th Amendment prohibition against cruel and unusual punishment. As a direct and proximate result of defendants' deliberate indifference to excessive risks of harm, plaintiffs have been injured, suffered severe and permanent pain, suffering, disability, impairment, loss of enjoyment of life, loss of care, loss of comfort, and economic damages, including but not limited to past and future medical expenses, loss of income, and damages. Plaintiffs may also require additional medical and/or hospital care, attention, and services in the future. Plaintiffs seek compensatory and punitive damages together with interest to compensate them for the violations of their rights by defendants. Plaintiffs seek declaratory and injunctive relief on behalf of themselves and a class of similarly situated persons to prevent further violations of their rights by defendants. Count 7. The lead plaintiffs and class plaintiffs are entitled to protection of constitutional rights under the 8th and 14th Amendment, including protection from deliberate indifference to their safety and well-being. At all relevant times, the collective defendants were responsible for operating Fulton County Jail, funding operations at Fulton County Jail, directing activities of staff, detention officers, and detainees at Fulton County Jail, and conducting, documenting, and performing necessary and essential functions in the operation of Fulton County Jail. The claims against defendants are based on negligence, policies, customs, and deliberate indifference at Defendant Sheriff Labatt, Defendant Jackson, Defendant Napcare, and all medical and administrative staff and detention officers responsible for the conditions at the Fulton County Jail. At all relevant times, defendants acted under the color of law. At all relevant times, defendant Napcare and medical professionals employed by Napcare acted with deliberate indifference to serious medical needs of class action plaintiffs, which constitutes unnecessary and wanton infliction of pain to class action plaintiffs. Farr versus West. Plaintiff Jackson suffered injuries in a shanking attack on the 6th floor of the North Tower at a time when there was no tower officer assigned to that floor. The presence of a tower officer would have deterred the attack on Shannon Jackson, Exhibit O. Defendant Labatt has advised members of BJA, DOJ, and NIC that the number of uniformed staff vacancies in the jail is at a critical staffing shortage level. Each defendant is aware that the jail's failure to provide adequate staffing and supervision to keep detainees safe exposes detainees to an increased risk of injury, serious illness, pain, suffering, mental health decline, and death, and each defendant has failed to take steps to reduce risks of harm, violating the 8th and 14th Amendment prohibition against cruel and unusual punishment. As a direct and proximate result of defendants' deliberate indifference to excessive risk of harm, plaintiffs have been injured, suffer severe and permanent pain, suffering, disability, impairment, loss of enjoyment of life, loss of care, loss of comfort, economic damages, including but not limited to past and future medical expenses, lost income, and other damages. Plaintiffs may also require additional medical and/or hospital care, attention, and services in the future. Plaintiffs seek compensatory and punitive damages together with interest to compensate them for the violations of their rights by defendants. Plaintiffs seek declaratory and injunctive relief on behalf of themselves and a class of similarly situated persons to prevent further violations of their rights by defendants. Prayer for relief. For the foregoing reasons, plaintiffs respectfully ask that this court, 1, assume jurisdiction over this action, 2, certify this case as a class action under Rule 23 of the Federal Rules of Civil Procedure, 3, declare that defendants are violating the 8th Amendment and 14th Amendment rights of plaintiffs and other class members as described in this complaint, 4, enter preliminary and permanent injunctive relief against defendants, requiring defendants to develop and implement a comprehensive plan to reduce the availability of raw materials that are used to create handmade shanks, and establish policies that ensure safety and security of all people in Fulton County Jail and ensure all staff adhere to them, including by training staff, supervising staff, and holding them accountable for violating jail policies, and establish general accepted classification systems and housing plans for incarcerated people that incentivizes pro-social behaviors, de-incentivizes misconduct and offers adequate protections to vulnerable populations, and conduct an exhaustive review and analysis of cell door locking mechanisms and zone door locking mechanisms with the primary goal to eliminate detainees' ability to pop locks, pop doors open, and hold doors open without authorization, and consider replacing or modifying the locking mechanisms to eliminate failures and improve detainee safety, and retrain staff as to use of force requirements, modify existing plans and policies to adhere to constitutional standards for this use of force, promptly discipline staff for misconduct, and implement and ensure adherence to thorough sanitation policies, ensuring regular scheduled cleaning and sanitation for all areas of the jail, in particular cells, medical areas, and food preparation areas, and develop and implement a comprehensive integrated pest management system for all parts of the jail to reduce and eliminate pests, and modify and implement policies, procedures, and practices for medical care in the jail to ensure adhere to constitutional standards for responsiveness to medical needs, including but not limited to mental health treatment. Implement a grievance procedure that is readily available and adequately responds to grievances filed by detainees. Enter judgment in plaintiff's favor for compensatory relief for injuries suffered at Fulton County Jail, which were caused by stabbings, health conditions arising from unsanitary and bug-ridden conditions, and excessive use of force by detention officers. Enter judgment in plaintiff's favor for punitive damages together with interest, and that a jury trial be held on all issues, and awards plaintiffs reasonable attorney fees, expenses, and costs of litigation, and a written consent decree monitored by the court to ensure the completion of the aforementioned requested relief, and award such other and future relief as the court deems just and proper. This 10th day of December 2024. Respectfully submitted, Michael D. Harper, PC. Certificate of Compliance pursuant to Local Rule 7-1D, I hereby certify that the foregoing has been prepared in compliance with Local Rule 5-1B in Times New Roman 14 point typeface. Respectfully, Michael D. Harper.
Thank you. What are you doing to your doggy? Why is your doggy barking? People think it is Kobe.
You know what? The dog is on the other side. He wants to come in, and I've got him on the other side of the door so that he wasn't barking in the room that I'm in while I was reading. That's what it is.
Everybody asking for Kobe, and Kobe over here trying to figure out what's going on. Right, Kobe?
No, he's just on the other side.
Okay, thank you. Thank you so much. So that's it. I said, don't blame him. You know, they try to blame poor Kobe. Kobe said, I'm quiet. See, I'm quiet. Look at him. Look at Kobe. He said, I'm quiet.
Sitting in the corner, being quiet. Yeah.
Kobe said, I'm quiet.
That's my baby Deuce making all that noise.
Deuce.
Yep, Deuce making all that noise.
Kobe said, that was not me. Don't be trying to blame me, y'all. Thank you, Mo.
You're welcome. I'm going to jump down now. I'm not sure how to get off, but
I'll kick you off.
Okay. Thank you.
All right, honey.
Bye-bye.
Bye. Does anybody want to come up? Does anybody want to come up, guys? Kobe said, no, that was not me. Y'all try to blame me. Kobe said, nope. Well, Kobe kept hearing the dog noise. He kept saying, trying to figure out what the heck is going on. All right, get down. Get down, Kobe. Get down. All right. All right, y'all. But that was it. You guys got the gist of it. We're going to show the exhibits later on. I got all the exhibits for you guys so you guys could get a chance to look at it. I really hope others will get on this suit. This is heartbreaking. So many loved ones to suffer through so much mental and emotional. Yes. See, Tori try to blame you, Kobe. You see that? She gonna try to blame you. Try to blame you, Kobe. He looking like, okay, what the heck y'all blaming me for? But that is it. Anybody have any questions? Anybody have any questions? Let me see. Let's see if I can see some more exhibit pictures. Hold on a second. Okay, we were at. That was terrible. That's a lot of incident report. Oh, this is the Shannon Jackson report here. We're going to read that one. Okay. This is the report for Shannon Jackson. Oh. You see this one right here? It says, on July 4th, 2022, the Deputy D. Gibbs was assigned to the Fulton County Jail as an officer on 5 South. At approximately 0024, I instructed the tower officer to open Zone 500 to conduct feeding. I noticed that 517 door was red and not properly secured. I went to the sergeant office to get a pair of gloves so that I could remove the object that was lodged in 517. En route back to Zone 500, inmate Shannon Jackson, 2203869, ran into Zone 700 with blood flowing from his body. I immediately cuffed inmate Jackson. Why would you cuff him if he got blood running through his body? Thank you for reminding me. Thank you for reminding me. They said, watermark. They cuffed him. Okay, he immediately cuffed Jackson. I attempted to question inmate Jackson, but he did not inform me what happened. I went to Zone 500 and secured all inmates behind their cell doors. Inmate Jackson was escorted to medical and sent to Grady Memorial Hospital for further evaluation. End of statement. Okay, here we go. Okay, listen to this. On June 5th, 2022, a Deputy Sheriff Sergeant R. Williams, and then you give it a number, was assigned to supervisor floor 700 North inside of Fulton County Jail, located in Atlanta, Georgia, at approximately 0110. I received word from Deputy Sheriff D. Gibbs that he needed me to investigate a stabbing that occurred on 5th Floor 5 South. Being told that the victim, inmate Shannon Jackson, was already transported to Grady Hospital, I immediately headed to security to view the Pelco video surveillance footage of the incident. With the help of Deputy Gibbs, I was able to identify the assailant in inmate Stanley Jalen of cell 5S507. He can be seen running from the top tier of Zone 500 to the bottom tier where inmate Shannon was standing and engaged in a fight with him. It was at this moment that inmate Shannon got stabbed by inmate Stanley. I went down and I next went to floor 5 South to interview inmate Stanley. Initially, he told me that he didn't have anything to do with it, despite me telling him that I have already viewed the camera footage. However, after having a change of heart, he spoke to me again and told me what was really going on. According to him, inmate Shannon shot up his mother's house while inmate Shannon was still free. Prior to his incarceration, he went to say that once inmate Shannon was arrested and housed in 5 South, he became a bully in the zone that he was in, Zone 100. Inmate Shannon attempted to continue to his bully mentality and behavior, and he was relocated to Zone 500, where inmate Stanley is housed. However, due to the younger median age of the zone, he did not tolerate his bullying behavior and constructed a way to get rid of him. It was facilitated via his stabbing. Due to his action in violating the rules of set forth in Fulton County Jail Inmate Handbook, inmate Stanley will be charged with a Category 3 offense, serious 3-2 assault and battery. This carries with it a 28-day assignment of disciplinary lockdown zone. On July 5th, 2022, a Deputy Lieutenant Mimler served as assistant watch commanders on 7 a.m. to 7 a.m., I guess 7 a.m. shift. I notified of the altercation on 5 South in Zone 500. Report synopsis, assault or battery. Final action. I reviewed the investigative summary completed by Sergeant R. Williams, and I agree with recommendation that inmate Jalen Stanley shall receive the following jail disciplinary sanction: 3-5 assault or battery. Additionally, it is my recommendation that inmate Jackson Shannon be relocated to another floor for his safety. End of statement. Okay, so that's what happened to Shannon. Stanley's the one that stabbed him. This is crazy, right, y'all? This is crazy. Crazy. We're gonna go through the exhibits later on, but anybody want to come up and view their opinion?
I didn't get that. Could you try again?
I wasn't talking to you.
Okay.
I wasn't talking to her. Why is she all in my business? No picture of Shannon. I didn't see any picture of Shannon. It might be a picture. Let me see. Let me see the next one. Hold on. I didn't see a picture. This is the December stabbing of Shannon here. Y'all want to hear that one? Y'all want to hear that one? That report? Okay, hold on. This one is a long report. Hold on. Let me go ahead and show this one and put my stuff back up. All right, here we go. All right. Here we go. All right, this here, I'm not going to read the numbers and all that. We're just going to do that. On Sunday, December 10th, 2023, the Deputy Nash, I'm just going to do the last name. Deputy Nash had been assigned to 6 North as the floor officer within Fulton County Jail, working overnight with Team D, 7 a.m. to 7 p.m. Upon 22:45, what time is that? 22:45? That's like 10:45, right? 23 is 11. Sorry, Kobe. I didn't mean to hit you in your head. Sorry. I'm sorry. At 22:45, I received traffic via my county-issued two-way radio that diabetic nurse was en route to 6 North for a few of the inmates housed on the floor. Per usual, I performed a visual security round in all zone before the nurse is escorted to on the floor. As I walked out of zone 700, I looked into zone 400 and seen activity that appeared to be suspicious. And I approached zone the zone door to perform my visual round and noticed inmate crowding the top level in zone 400. As I was observing the scene, inmate Walker Lester began to attempt to wave me off, advising me that nothing was going on in the zone and to move around. Inmates were just debating about the game that was on. As I ignored him and continued to observe the scene, inmates started scattering around the zone. I noticed inmate Huey Marquavius taking off his shirt and appearing to look angry. I then opened the zone solar port door to investigate what was going on, but noticed the nurse had been escorted onto the floor. I called for inmate Anderson Christopher to get out to get his diabetic medication. As I called Mr. Anderson, Mr. Huey walked to the door and stood there for a second. And once I took my eye off of Mr. Huey. I noticed Mr. Jackson Shannon approaching me with blood all over him. Once he got close enough to me, he stated he needed to go to medical and be seen. Nurse McKinney and Deputy Johnson escorted Mr. Jackson onto Zone 700 for care for him at that time. I locked the zone down and noticed inmate Brown, Willie. Y'all remember Willie Brown? He's the one who injured his child. He emmed his child. He murdered his child and stomped this child on the floor. Oh, I got to tell you about him because I went and did his record. Okay, Willie Brown, clothes ripped and appeared to look angry. I immediately pulled him out of the zone and placed him in zone 800 while being cuffed to the back. Upon all available officer, I can't even see. Okay. Upon all available officer arriving to the floor, I removed Mr. Brown from zone 800 and placed him in zone 700 and conducted my interview. I asked Mr. Brown to tell me exactly what happened, and he stated Mr. Jackson, told me he wanted his one. He wanted his one. I informed him to speak English so that there was no misunderstanding. He stated Mr. Jackson, told me he wanted to fight me. I was standing there talking to my buddy, whom remained anonymous, was talking to, and we will find out via camera footage, and he said he can find out that way. Then I don't understand what this lady's writing, but after that, I proceeded to go further into the investigation, asking what happened next. Mr. Brown stated, I went into his room and pulled out a knife on me. And he pulled out a knife on me, and I took it from him and stabbed him with it. I asked Mr. Brown, so he pulled out a knife on you, but then he pulled out a knife on you. Mr. Brown said, no, I took it from him and stabbed him with his knife. Then I checked Mr. Brown for wounds that might have occurred during the altercation. He didn't have any. Upon Mr. Sergeant Obasi investigation, he came back to 6 North and questioned Mr. Brown again, and he gave Sergeant Obasi the same information he provided to me. Both interview has been conducted on my county-issued Axon body camera. Mr. Brown should be charged due to the matter at hand. On Sunday, December 10, 2023, Detention Sergeant Obasi was assigned as a roving supervisor at Fulton County Jail for the 7 a.m. D team. At approximately 22:50 hour, I responded to a help call from 6 North with Major Hinton and Captain C. Taylor. Upon arrival on 6 North, I witnessed inmate Shannon Jackson, housed in cell 412, sitting at the bench of Zone 700 and was being attended by a group of officers and the nurse McKenzie. Due to the bloody nature of the scene, it was later discovered that inmate Jackson was stabbed multiple times by another inmate who was later identified as inmate Willie Brown, housed in cell 418. Initial officer statement. According to the Deputy Nash, at approximately 22:45 hours, while waiting for the diabetic nurse to arrive on his floor, he conducted a visual security around all zone before the nurse is escorted to the floor. On the floor, as he walked out of zone 700, he looked onto zone 400 and observed activity that appeared to be suspicious in the zone. When he went to 400, he observed. Okay. When he went to 400 to perform his visual round, he noticed inmate crowding the top level in 400, zone 400. As he was observing the scene, inmate Walker Lester began to discourage him from going into zone 400, advising him that nothing was going on in the zone and to move around. He was informed that inmates were just debating about ongoing games. He ignored inmate Walker and continued to observe the scene, and the inmate started to move around the zone. Deputy Nash noticed that inmate Huey McQuadius taking off his shirt and appeared to look angry. When he went into zone 400 to investigate what was going on, but noticed the nurse had been escorted onto the floor. Afterward, he noticed inmate Shannon approaching with blood all over him, stating that he needed to go to medical and be seen. Nurse McKenzie and Deputy Johnson escorted inmate Jackson to zone 700 for care. He also noticed inmate Brown Willie clothes ripped and he appeared to look angry. Deputy Nash immediately pulled him out of the zone and placed him in zone 800, cuffed to the back. When additional officers arrived to the floor, inmate Brown was moved to zone 800 from 800 to zone 700 to be interviewed and conducted my interview. During his interview with inmate Brown, he informed Deputy Nash that inmate Jackson wanted to fight him. He also stated that he was standing there talking to his buddy who remained anonymous, and he said he wanted to fight. Inmate Brown confessed that he went into his room and pulled out a knife on him and took it from him and stabbed him with it. Deputy Nash checked on inmate Brown for any wounds that he may have sustained during the altercation, and he didn't have any. Inmate statement. I tried to interview inmate Jackson in zone 700. Due to the severity of his injury, he was not able to respond to any of my questions before he was taken to Grady Memorial Hospital by EMS. Interview with inmate Willie Brown. During the interview, I asked inmate Brown to tell me what happened. Inmate Brown stated that he and inmate Jackson were supposed to be fighting and that he had told Officer Deputy Nash included to move him. He admitted going into the cell 412 where inmate Jackson is housed to fight him. He also stated that inmate Jackson had a knife. I asked him why did he not sustain any injury like inmate Jackson if he did not have a knife. He informed me that inmate Jackson reacted when he saw him. I also inquired from him if he needed to be seen by a medical provider. He replied yes and stated that his back hurts. The interview with both inmate Jackson and Brown was conducted with my county-issued Exxon body-worn camera turned on. The video footage of the incident viewed with the following result. At 10:33 10:15 p.m., inmate Brown is observed standing in front of cell 410. At 10:45 p.m., inmate Brown is seen to move from cell 10 to cell 412, from cell 412 to cell 413, and back to the magnesium. At 10:45, inmate Jackson is seen going downstairs to cell 408. At 10:46:08, Deputy Nash is seen at zone 400 entry, but went back out few seconds later. At 10:46:41, inmate Jackson is seen walking out of cell 408 towards zone 400 entry door. At 10:46:47, the floor officer enters a zone 400. Conclusion. Based on the interview and the video footage, it is my recommendation that inmate Willie Brown be charged with the following jail rule violation: 3-2 assault or battery, 28 days; 3-7 interfering with security operation, 28 days; 4-2 any inmate that causes bodily injury to another with the use of a sharp-edged tip weapon, 90 days, a total of 146 days. The above listed are the maximum number of days on lockdown for inmate Willie Brown in accordance to Fulton County Sheriff Handbook. This investigation will be forwarded to the unit manager for further review and approval. I also recommend that the Jail Investigative Unit, JIU, continue with the investigation and possible outside charges on inmate Brown for stabbing inmate Jackson in the statement. And then it says here on December, who's this? Baxter. This is another report. Okay, here we go. On Sunday, December 10th, 2023, approximately 10:49 hours, I, Sergeant D. Baxter, was working a special unit, NAFCARE, along with LPN Nash, LPN McKenzie, with diabetic sick call on 6N. While posted on zone 400, waiting for Deputy Nash to pull the individual out for diabetic check, I observed inmate Shannon Jackson exiting zone 400 covered in blood. I proceeded to ask Jackson what happened, but he said he could not breathe and continued to walk to zone 700. I and Nurse McKenzie immediately started applying pressure to Jackson's open wound. I noticed that Jackson had been stabbed in the top left shoulder, lower back, right back, and right side under his rib cage and his stomach area. I called for assistance on my county issue radio. Several other FCSO unit responded to render aid. I continued to render pressure until I was properly revived by the NAFCARE doctor provider. Jackson was escorted to the old intake lobby to be transported to Grady Memorial Hospital for further treatment. I, Captain C. Taylor, have read the incident report. It is in its entirety. I recommend that criminal charges be put on inmate Willie Brown for assaulting inmate Jackson. I also recommend that this incident be investigated further by Jail Investigation Unit Division due to the nature of the incident. All right, that was that with Jackson. Y'all see that? So, all right, I'm about to end this live, y'all. It's just terrible. It's a lot. The report is over 220 some pages, or 230 something, 200 something pages of this document. It has a lot of exhibits in it. We can go over it another time, but my mouth is dry. It is crazy. He's been stabbed 3 incidents, y'all. And this time he was stabbed like several times, shoulder, the back, the stomach, and under his ribs. It's terrible. I tell you, Shannon has a purpose in his life. Oh, yeah, I have an interview to do at 7 o'clock, so I have to be prepared. Hankin TV is where the interview is going to be at. Hankin TV. So I need to go ahead on and get off this live, and I will check you guys later. Kobe, you ready to eat? Okay. Kobe's down here. All right, y'all. I will see you guys later. Peace out. You guys, thank you for... Don't forget to subscribe. I have more updates for you guys later on, but I got to do this interview. I got updates with Eppinger I was telling you about, and also with Fleetwood. I have interviews with them. Not interviews, Lord have mercy. I'm thinking my interview. I have updates we're having to do with them, okay? And I'll be back. So look for me after my interview with Hankin TV. See you guys later. Bye.
Thank you for watching the infamous Sylvia channel, where laughter and fun make up our panel. Together we build this digital spree. We appreciate you and our growing family. With mods by our side and chat flowing free in this online space. It's just you and me. We laugh until tears roll down like the rain. In this virtual world, you ease all my pains. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. We cherish the moments, the highs and lows, from the latest gossip to stories untold. You're more than a viewer, you're part of the crew in this space of ours. It's all because of you. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With With every sign enjoys what we'll gain. We're a family, not just a show. Every click and comment makes us grow. Minds in check, keeping